Welcome to the Divorce Podcast, where we explore all aspects of ending relationships, separation, and parenting apart. If your marriage or partnership has ended, or you have friends and family who are separating, this podcast is for you. I'm Kate Daly, a relationship counsellor, divorce specialist, and co-founder of Amicable, the online legal service for separating couples. In each episode, we look at relationships and separation from different angles, including the emotional, legal, and social. I'm joined by experts and special guests who share their own unique stories, experience, and tips with the goal of helping people end relationships in a kinder and better way. In this episode, I was joined by Angela Lally, who's a qualified solicitor specialising in family law, to discuss cohabitation when a relationship ends. With over 20 years' experience, Angela has focused her practice on the financial aspects arising out of relationship breakdown for both married and cohabiting couples. We begin the episode by discussing the rights cohabiting couples have compared to those who are married or in a civil partnership. Many will be surprised to learn there is no such thing as common law husband or common law wife, and that this myth can have some dangerous financial consequences. We look at ways to protect yourself from future conflict if your relationship breaks down after cohabiting, and the complications around property, whether or not your name is on the deeds. Perhaps the biggest contrast between how finances are dealt with between married and cohabiting relationships is to do with pensions and the inequality this can create for anyone sacrificing a career to care for children. We finish with our thoughts on cohabitation law reforms, and in their absence, the advice to make sure you engage your partner in a conversation about your finances if you're cohabiting in England or Wales. If you really loved this episode or want to hear more episodes like this, then please make sure to rate us on your preferred listening platform. Enjoy the episode. Welcome, Angela.
Thank you, Kate.
It's lovely to see you. Thanks so much for joining us. Angela and I have known each other for a very long time, passing work to and fro, and she's been a constant support for Amicable and the business. So it's really lovely to eventually get you on the podcast, Angela. Thanks so much for joining us. Today's talk is really all about cohabiting couples and what happens when you separate and you've got, say, it's money and property and you're not married. And we know that cohabiting families are the fastest growing family type in the UK. Almost 4 million, around 3.7 million at the moment, families are cohabiting couples. So it's a really big issue, and it's one where there's very little known about what happens when you separate when you're cohabiting. So it's a really great opportunity just to bust some myths and have a chat about this particular area. So let's start then, Angela. Let's try, if we can, to define cohabitation. So where do you draw the line? What's cohabitation and what's having a boyfriend or a girlfriend and staying at theirs for a few nights a week? Is there a legal definition or is it something totally different?
I think the best way to describe cohabitation is that it refers to two people who are in a relationship, not just sort of like a lodger, an actual intimate relationship, maybe if you describe it that way, but they're not actually married or in a civil partnership. So there's no minimum or maximum period of time. I think that once the timeline extends, so they've been together a longer time living together, their finances become a bit more entwined. And then the difficulty then is to then look at how that is then separated if there is a separation subsequently. So I would say that there's no sort of minimum or maximum period for cohabitation, but the longer the cohabitation, the more the couple become intertwined in respect to their financial matters. And obviously, if they've got a family together, bringing up children together, then the longer that goes on, the more sort of complicated that becomes if there is a subsequent separation. And I think that in terms of sort of the statistics, I think marriage rates are at the sort of lowest record since 1862. I think that's the Office for National Statistics information from the latest census. So obviously there's a lot of families who are not in a married situation and quite often don't know what their rights are if that relationship breaks down. Obviously, nobody goes into a relationship expecting it to break down. And sometimes these things aren't thought about. Life gets in the way. And before you know it, months or even years have gone by without any thought to how the finances might be impacted if there is a separation.
Sure. Well, it's quite an exciting time, isn't it? Often when you move in with somebody, and yeah, like you say, the last thing you're thinking about or planning is what happens if we split up. So I can see that totally. We'll come back to that. But just before we move on to that area, I think one of the things that always surprises me is the number of people who believe in this idea of common law husband and common law wife. And I know as people that, work in this sort of area, we get this a lot, don't we? But let's bust this myth once and for all. Is there such a thing as a common law husband and wife?
There isn't. And that does come as a surprise to many clients who make an inquiry and say, I've been living with my partner for 6 months. That means I'm common law husband or common law wife. I try to actually get to the bottom of where the term came from, because it's interesting that it has become something that people refer to. And I think it is just one of those misconceptions over time. There's no legal recognition of a cohabiting relationship. The only legal recognition is in relation to either married or civil partnership, which then confers financial rights. So I think that is where, unfortunately, people fall into a bit of a trap of, oh, we've been together 6 months, we've been together a year, 2 years. There's all sorts of random sort of timescales that are stated when clients make inquiries, but there isn't. And it is unfortunate that myth perpetuates.
We need Susie Dent, don't we? I'm tempted to write into her and ask her then where that comes from, because that's interesting, isn't it, to understand where that word's come from. So let's just unpack that again then. So if there's no legal recognition of cohabiting, as in inferring any rights on a person, then are there no rights if you cohabit? Do you have no legal status at all, or is it more subtle than that?
So there are no legal rights flowing from the cohabitation itself, but by virtue of the fact that somebody's cohabiting means they're in the same property. That property might be owned by one person or jointly. That's what gives rise to potential claims. It's the actual asset as such rather than the right flowing from the cohabitation, if that makes sense.
So it's the ownership of the asset where there might be some discussion to be had around how it's split if you separate. But there are no rights. Like there are rights if you're married and you separate, or you divorce rather, and there are no, if property or assets aren't in your name, you still have rights despite that. But the distinction here seems to be that if the asset isn't in your name, then there are no legal rights flowing from that.
It's not quite that straightforward. So, for example, with a property, it may be in one person's sole name, but there may be a beneficial interest claim, which we can sort of explore in more detail. But just touching on the marital situation, as soon as you marry, your rights against your financial claims arise, income, capital, pensions, regardless of how long the marriage is. The longer the marriage, the more you're looking at dividing assets equally. But by virtue of the fact that a marriage has taken place, that in itself gives rights to potential claims, whereas that's not the same with cohabitation. So then we have to unpack it in terms of what potential claims there may be arising from specific assets, and that quite often is a property, a house.
Okay. So it's quite a precarious type of relationship then. So you could have children, you could have been together for a long time, but really there isn't very much protection by the sounds of it if you're entering a cohabiting relationship.
I think that the main difference is if you're married, then in the event of a divorce or separation, you know that ultimately a court can provide for you if there are children and needs, and all of that gets taken into account. Whereas with the cohabiting relationship coming to an end, if we're looking at specific assets like a house, then we're looking at legal concepts such as trust law. So how is the property owned legally? Is it in joint names or sole legal names? If it is in sole legal name of one of the partners, then the onus is on the non-owning partner to try and establish a claim. So it does become more difficult and more complex to assert that claim. Whereas with a married couple, it's just as of the fact of the marriage that those claims are there.
So it sounds like there's a lot more proof required if you want to establish a claim against a property. And I guess, you could establish the claim on the grounds that you've contributed to that property, even if it's not held in your name. Talk us through that then. What would give rise to a claim on, say, a property?
Okay, so just to give the example of, say, the property is in the sole name of one partner, the other partner moves in. The agreement between the parties is that the non-owning partner pays the utility bills, pays for the food shopping, doesn't make any contribution directly towards the purchase of the property. There's not been any discussion about this being the family home or this person having an interest in the property. In that situation, then regardless of the length of that cohabiting relationship, that non-owning partner may have difficulties trying to establish a financial claim. It isn't a straightforward area of law. It would be difficult for me to give examples of, each different scenario, but on the whole, the burden of proof is with the non-owning partner to prove that they've got a claim, even though they may have been the person who isn't contributing towards the mortgage or the purchase of the property because they may have given up work to raise the children, for example. That might have been a decision they've made as a couple. But then that person potentially is penalised because they've not made that financial contribution towards that property. So it is a precarious position to be in, but could be preempted, for example, by the couple giving some thought to how the financial matters may be dealt with by entering into a living together agreement, for example, to say, right, okay, this is how we need to deal with it. Or the non-owning partner having a declaration of trust in relation to the property to set out what their share would be. So there are ways around it. It's just that, as you say, quite often you go into a relationship, you're not giving any consideration to what happens in the event of separation. It's not particularly romantic. So let's sit down and work out who's getting what when we split up, when we've only just moved in. So just as life gets in the way and children come along and life gets busy, it's only then in the event of separation that somebody may give thought to, well, hang on a minute, what about my share? Just as when couples go and purchase a property in joint legal names, one person may have put in more of a deposit financially, an extra £10,000, £20,000. They're then surprised to find that actually they might not be entitled to get that back unless the property ownership's been set up in a certain way. So it's a bit of a minefield, really. And it's, I think even, at the outset, when a couple go to purchase a house, they really need to give some thought to, how that's going to be dealt with to sort of, prevent any problems later on.
So it does sound like there are some things you can do, but you really need to have that conversation together to work out what's fair and what's right, and then to go and find the legal way of documenting all that whilst you're on good terms, rather than just ignore it, risk the relationship breaking down, and then when everybody's upset, having to go back and try and unpick this. And often, by the sounds of it, coming out realising there really isn't very much recourse, legally at least. There may be morally, and obviously that doesn't stop people having, mediation or negotiation help to come to an agreement that they're both happy with. But it doesn't sound like there's much recourse from a legal perspective.
It's certainly more complicated and more limited than in a married situation. So yes, to have those discussions at the start is probably sensible, but as we've said, probably doesn't always, happen. It's the same way as a prenuptial agreement. It's, those situations where people are giving thought at the start of the relationship to what might happen to their assets, it usually happens when they've each come out of a previous separation and they've got assets to protect. I find that it's less so in like a first-time relationship where you're not contemplating the separation. I think one other thing to consider as well when we're looking at the different claims is that if there are children, there is potential protection under the Children Act, the financial provisions under the Children Act. Children Act is usually dealing with arrangements for the children, how often the children see each parent, which parent the children live with. But there are also financial provisions as well. So if there is a house in one person's name, it could be that the non-owning partner, maybe the main carer of the children, may be able to stay in the house till the children are no longer dependent. But again, it's not a straightforward matter to deal with and could cause a lot of upset, particularly if the parties are trying to remain amicable for the sake of the children arrangements.
And in that scenario, the option is to stay in the house, but you're still not getting a share of the house once the children are grown. The house at that point reverts back to the owner of the property, doesn't it?
That's entirely right, yeah.
So you're kicking the can down the road in terms of your own housing, but obviously there's a benefit to ensuring the children's continuity of home is there, isn't there? And they can continue to attend school and etc. Gosh, it sounds complicated. And whenever there's a complicated legal situation, it starts to rack up the pounds, doesn't it? This is an expensive area for people to have to navigate. We talked briefly about this idea that having these conversations at the outset is important. And yes, perhaps culturally in this country, we aren't very good at that. But if you can have that conversation, if you can have a grown-up conversation, perhaps, as you say, it's not your first cohabiting relationship. What can you do if you have that conversation? What sort of agreements can you put in place? And are those agreements legally binding?
Yes, I think if the conversation does arise, the couple are able to discuss what may happen with the house or anything else they've purchased during the course of the relationship. If they can have that discussion and decide, if we do split up, this is what we're going to do, then you could be looking at a cohabitation or a living together agreement to set out what would happen. And that's because there are no court proceedings, because there's no litigation. The agreement doesn't get filed with the court or anything like that. It's an agreement between the parties, but is more likely to be watertight if they each take separate legal advice and there is some disclosure of their financial position so that they're going into it with their eyes open.
Well, that's quite an interesting concept, isn't it? Because I wonder how many people, and I include myself in this, have moved in with somebody at some point and never thought to ask about what their finances were like, or, even if they've got any debt, or, I've never asked anyone if they've got a county court judgment against them. But obviously, if you're sharing an address, that can have an impact, can't it?
Yeah, I mean, I suppose the disclosure of the finances, I suppose, may be more relevant in terms of the house, what the value is, what if they're contributing, what share they may get, that kind of discussion about the sort of disclosure, less so than in, marital situation where you can claim against everything. So, for example, in a married couple, pensions are an asset that can be shared. That's not the case in the cohabitation situation. So it's a different situation in terms of what information that person would need before entering into that agreement. I mean, I think pensions is an interesting one from a point of view of, obviously, for cohabitation. It may be that the couple organise their finances, which means that one of the partners does have the finances available to put into a pension. Maybe the other partner is actually using the money to pay for the household bills, etc. But then find that they've then not got pension provision. So, especially in a longer relationship, that might be, as the pension grows in value for the person who's got the pension. So there's all sorts of things to think about, not just the house, child maintenance, but how both parties are going to sort of be provided for in the future.
So just to clarify then, even in a long-term relationship, you can't make a claim against the other person's pension, even if you've been the one who, as you say, has sacrificed a career to look after children, for example. There's no legal route or recourse for claiming any kind of pension.
That's correct. And so that's in complete contrast to if you're married, where the pension is a marital asset that's capable of being divided.
Yeah. It really is leaving some people in a very, very vulnerable position, isn't it? And the government had the opportunity, I think, back in September to open up this area and start to look at whether or not laws should be put in place to protect cohabiting couples, but chose not to do that. So it feels like there is going to be a long wait before people who choose not to marry and choose to cohabit have the protections and enjoy some of the protections that perhaps they don't realise even that they don't have.
Yeah, that's right. And, and it's been something that's, been needed to be looked into for, a number of years. And it looked like it was getting to the point where actually something might be done about it. And then no, it may be that it does at some point and, who knows. But yeah, it is. I think it's important for people just to go into a cohabiting relationship with their eyes open and maybe if it's a few weeks, a few months, it's not something that they may be concerned about. But I think once it starts to sort of, the relationship is much longer, and especially then when the situation changes, if children come along and one person gives up work, that kind of thing, it might be a catalyst to then say, okay, let's look how we're going to deal with our financial situation if anything happens.
Yeah, well, I think you're right. I mean, we should call it as it is. This strikes me as it's potentially affecting caregivers, and the majority of caregivers at this point still are women, and therefore it's likely to negatively impact women more than it does men, particularly in terms of pensions and, like you say, giving up a career to stay at home and care for children. It feels like there's just people just don't understand or don't know. It feels like we need some kind of quite high profile campaign to build that awareness so people can make informed choices.
And then maybe even looking on being skeptical, and you may even think that some people may know, one partner may know, and is choosing not to pop the question and say, let's get married for that reason. I think that could also be a reason as well, to think, well, I'm not going to tie the knot because I know what that will give rise to, claim against my pension and my business and my savings and so on. So,
but in some ways that can be a bit of an unfounded worry, can't it? Because now you can have a prenuptial agreement. So you can enter into a marriage with an agreement with your partner to protect any pre-acquired assets or an inheritance that you think is coming down the line. So there are ways of still protecting assets and marrying to give security to, the weaker financial person in a relationship.
Yes, certainly prenuptial agreements have been on the increase. Just to explain, a prenuptial agreement is not an enforceable contract in its own right. It's a factor a court would take into account. If a married couple were to separate, it's one of the factors the court would look at. But if there has been independent legal advice, full financial disclosure, the prenuptial agreement has not been entered into too close to the marriage, then it may likely to be upheld. It also has to be fair as well and meet the needs of the parties. So if it is too close to the wedding, then somebody can look at post-nuptial agreement to reinforce what they were going to agree before the marriage. So yeah, there are ways around that situation that somebody might not feel confident about getting married, especially maybe if it's the second or subsequent times, because they've built up their assets and they know how difficult it was to disentangle themselves from their former spouse the first time round.
And it's perfectly legitimate, isn't it? Because ultimately you may have assets or other things that you do want to protect, or people now have, the option of having second families and so on and so forth. So you might want to make sure that your children from a first marriage, for example, are able to inherit rather than the children of your new partner, for example. So they're all legitimate reasons why you might want to have this kind of, arrangement in place, aren't there?
Yeah. And again, it goes down to sort of that openness between the couple because, again, it's not the most romantic of things to put on the table and say, we're about to get married, but, if we split up, this is what should happen. So, but again, it's all part of that relationship and how that communicate that between themselves.
You mentioned a little while ago something called a trust when you're talking about properties. Can you just expand a little bit more in terms of what people can do when they're about to purchase a property to protect, who's put what in deposit-wise and that kind of stuff?
Yeah, absolutely. Again, buying a house, it's an exciting time. We're buying our first house together. Quite often the thought isn't given to, okay, well, I'm putting in twice the amount you're putting in. Should I not get the benefit from that if anything happens? So what quite often happens is if it is in joint legal names, the beneficial interest is held as joint tenants, which means that it's a 50-50 share of the equity, regardless of who's putting what. So there should be discussion potentially with the conveyancing solicitors when the property is purchased about how an unequal contribution can be protected by way of a declaration of trust or holding the beneficial interest as tenants in common in unequal shares. So that there are things that can be done. It just means giving that thought at the start. If it's something that arises after the property's been purchased and the couple decide that it needed to be dealt with in a different way, then again, they can take legal advice about declarations of trusts and different ways of owning the beneficial interest in the property. And ultimately, if they did separate and can't agree the shares in the property, then there's the Trusts of Land Act, which deals with property and trusts. But again, it's not ideal because it can be a very costly process if litigated. And it's better to think about that at the start rather than at the end.
Of course, we've talked a lot about the legal aspects of separating, obviously, because you're a lawyer. But what about people are free, aren't they, to make their own decisions about how they want to split things in absence of any sort of legal agreement? You can just decide as a cohabiting couple on what you think is fair and how you want to split things. And there's nothing stopping people from doing that, is there?
Absolutely. And, sometimes the last thing people want to do is get involved with solicitors. And the best agreement quite often a couple can reach is one that they reach between themselves. So, they arrangements can be made as to what they want the outcome to be. As lawyers, we don't tend to see those kind of situations because we're dealing with people who can't agree. So I'm sure there are many situations where cohabiting couples separate and make their own decisions and move on quite happily with that.
And people are free to document that themselves, aren't they? Or to use a different service to document those sorts of agreements. Nothing stopping them from doing that.
Yeah, I would say that if we give the example of one partner owning a property and agrees with the non-owning partner that they may receive a sum of money to reflect what they may have contributed towards the relationship or whatever the agreement they come to, it may be sensible for the person who owns the property to have protection by way of a separation agreement so that there are no potential claims in the future. So again, we say, if an agreement is reached, that's absolutely fine. But you don't know what the situation may arise in the future. The person who doesn't own the property may subsequently think, well, actually, I don't think I received enough, so I'm going to go back for a second go. I do get a lot of couples say, yeah, but they won't do that. I know them. We're parted on really good terms. But that does happen sometimes.
If someone is going back in that scenario, what can they claim then?
So they may, again, just give the example of somebody owning a property in their sole name. They've decided to pay a sum of money to their former partner. It may be that former partner then goes and takes some legal advice and finds out that actually the sum that they received doesn't reflect what they may have been entitled to had they gone and made a claim through the Trusts Act. So
there has to be, so in that scenario, what you're saying is the risk is only if there is a claim.
Yeah.
So if you're in a situation where you've never contributed to the mortgage, you've not contributed to the purchase of the property, you've lived there for a period of time, the owning partner says, well, we were together for a while or we had a child and you spent the first couple of years at home and therefore I want to recognise that. So where there would be no other claim, in that scenario, there's nothing to come back with, is there? It's just if the partner had a proper claim and is being paid off that legitimate claim, that's when there could be some comeback.
I would say, again, this may be being sceptical, but, if there was money changing hands, I think I would just like to see some agreement in play just so that both parties know where they are in terms of that.
And that would be what, a deed of separation?
Yeah, a separation agreement. Yeah, just setting out, what's been paid and why and the fact that there won't be any further claims in relation to the property.
And do you think there are any other areas, like traps, if you will, that cohabiting couples need to be aware of? Is there anything that we haven't covered?
I'm sure there will be. I'm sure somebody listening to this may say, but actually, what about this situation? But, everybody's situation is different. And I would say that sometimes maybe the traps people might fall into are to relate their situation directly to somebody else they know when the situation might, but I think that can happen in any separation, whether couple's married or unmarried. It's just really to find out what the legal rights are if they think that they might have a claim, but also then just to explore the best ways to reach an agreement without going straight down the legal route, and lots of ways to try and reach an agreement either directly or through mediation or through amicable, or lots of different situations that don't result necessarily in that relationship being completely fragmented when they may be in each other's lives if they have children together.
Brilliant. Well, listen, Angela, it's been absolutely fascinating talking to you. It's such a complicated area, isn't it? What are your top tips for people if they're going into a cohabiting relationship? What would you tell somebody?
Just to have an open discussion, especially if the one person is moving into the other person's house. How is this going to work? As I say, in early days, a few weeks, few months might not be particularly concerning, but longer it goes on, children come along. I think it's just a matter of being open and honest and working out what is fair, what is the fairest way to deal with the assets that, the property. And as we've said, the fact that one person may be able to put money aside for pension because the other person, is raising the children they're not earning. So I think it's just a matter of how is best to look at the financial provision overall. Yeah, that's probably it.
Get some advice, know your rights, make informed decisions. Yeah.
Absolutely.
Brilliant. Look, it's been absolutely fantastic talking to you. Thank you so much for your time, Angela. Really appreciate it. How can people get in touch? I mean, obviously, if people have got questions about this kind of stuff, you're presumably happy to talk and advise. So how can people get in touch with you?
Yeah, absolutely. So I've been qualified as a solicitor for 20 years to deal with all sorts of different situations in terms of relationship separations. So I'm always happy to have an initial chat with somebody over the phone just to reassure them, just to explore what the issues are, because sometimes it's a bit scary, the thought of speaking to a solicitor when you've not ever had to go down that route before. So I can be contacted, Angela, at rookledges.co.uk. The firm I work at is Rookledge Law, and we specialise in family law matters. And that's usually the best way of getting hold of me, and then we can arrange a chat.
Brilliant. Thank you, Angela. And you can find me on Twitter. I'm at Kate_Daly. You can hear about new podcast episodes by following at divorce_podcast. And if you've liked this episode, please like it and subscribe by visiting thedivorcepodcast.com. Thanks so much, Angela, and thank you so much for listening.